Even after a transaction closes and the keys are handed over, title and escrow issues can occasionally surface. From recording errors and missing releases to misapplied funds or incorrect prorations, post-closing problems require prompt, professional handling. Arizona agents who understand how to identify and address these issues while working within the boundaries of state law can protect their clients and maintain compliance with commissioner's rules and Arizona revised statutes. Understanding post-closing corrections. Once escrow closes, funds are disbursed and the deed is recorded under ARS, paragraph 33 to 411. However, closing does not guarantee perfection. Common post-closing errors include incorrect legal descriptions or parcel numbers, misspelled names or missing middle initials on the deed, failure to record lien releases, misallocated HOA fees or property tax prorations, title policy omissions or incorrect vesting. Arizona law allows for corrections through proper documentation and recording procedures, ensuring ownership and chain of title remain intact. Example: a deed recorded in Maricopa County accidentally omitted one digit from the parcel number. The title officer discovered the error and recorded a corrective deed under ARS, paragraph 33.411.01, which authorizes correction of minor errors through re-recording, as long as all original signatories approve the correction. Corrective and affidavit solutions. When an error affects ownership clarity, title officers will often request one of the following: corrective deed, used to fix typographical or clerical errors without changing ownership. Affidavit of correction, used for minor errors such as legal description typos, per ARS, paragraph 33.420. Affidavit of identity or successor, used to confirm a party's identity or rightful ownership after death in accordance with ARS, paragraph 14.3971. Agents should never attempt to draft these documents themselves, but can assist clients by facilitating communication between title officers, attorneys, and the county recorder. Example: a Gilbert couple purchased a home as John Smith and Mary Jones, but they were married at closing and intended to take title as John and Mary Smith, community property with right of survivorship. The title company corrected the vesting via a corrective deed, ensuring proper ownership form and compliance with Arizona community property laws. ARS, paragraph 25, Tarver 211. Unreleased liens discovered after closing. Occasionally, a lien that was assumed to be paid or released resurfaces after closing, especially older mortgages or judgments. In such cases, the title insurer is responsible for clearing the defect, as title insurance policies cover undisclosed liens existing prior to the date of policy issuance. Under ARS, paragraph 20, 1562, title insurance guarantees protection against losses from defects, liens, or encumbrances that were unknown at the time of policy issuance. Example: a buyer in Tucson discovered a $5,000 old judgment lien 6 months after closing. The title insurer verified that the lien predated the policy and paid for its release under the owner's title insurance coverage. The agent helped coordinate communication between the title company and the client, providing reassurance and professional follow-up. Misapplied funds or proration disputes. Another common post-closing issue involves inaccurate prorations of property taxes, HOA dues, or rent. When these discrepancies are discovered after COE, they can usually be resolved by reopening the escrow accounting or issuing refund adjustments. Example: a Chandler seller realized after closing that the HOA charged an extra $250 special assessment before transfer. The escrow officer verified the timing and issued an adjustment check to the buyer, correcting the overpayment. Agents should always advise clients to carefully review their final settlement statement, ALTA, after closing and immediately report any discrepancies. Timely reporting helps ensure compliance with ARS, paragraph 6.834, proper fund handling, and prevents disputes from escalating. Recording and indexing errors. Sometimes the county recorder misindexes a deed, resulting in the transaction not appearing under the correct name or parcel. Although rare, this can cause problems during refinancing or future sales. Example: in Pima County, a recorded deed was indexed under Maria Lopez instead of Maria Lopez. The title company discovered it during a refinance years later. Under ARS, paragraph 33 to 412, the recorder corrected the index entry, preserving the validity of the recording. Agents should encourage clients to verify recording within a few days after COE. Title companies usually provide the recorded deed and policy within 30 to 60 days, but agents can follow up to ensure clients receive copies promptly. Escrow, refunds, and overpayments. Occasionally, over-collected funds or duplicate payments occur due to lender or HOA adjustments after closing. Escrow companies are required under ARS, paragraph 6834C, to account for and refund any overage to the rightful party. Example: a lender in Phoenix collected property taxes twice by mistake, once through escrow and again through impound. When discovered, escrow refunded the duplicate payment directly to the borrower and documented the correction in its trust ledger to satisfy compliance requirements. The agent's follow-up role. While title and escrow companies handle the technical corrections, an agent's professionalism shines through follow-up and client care. After closing, agents should verify that clients receive recorded deeds and title policies. Encourage clients to review their final settlement statements. Assist clients in contacting escrow or title if discrepancies arise. Keep records of communication for at least 5 years. ARS paragraph 32.22151.01. Following up after closing not only builds trust but also demonstrates compliance with R428 to 1101A, acting in the client's best interest and maintaining high professional standards. Example: a Flagstaff agent called a client 2 weeks after COE to ensure they received their recorded deed. The client hadn't yet received it, so the agent contacted escrow, who mailed a new copy immediately. The client's appreciation later led to a referral, proof that attention to post-closing details strengthens long-term business relationships. Key takeaways. Post-closing issues can and do occur even in well-managed transactions. Arizona law provides remedies through corrective deeds, affidavits, and title insurance protections under ARS Titles 33 and 20. Agents should always maintain communication, confirm documentation delivery, and document any corrective actions to stay in compliance with Commissioner's Rules R428-1101 and R428-802A.